Okay, let's unpack this. Forget the action movies for a second. Imagine a multi-million-dollar property dispute, tangled up in family conflict, and accusations of broken promises after a death.
Sounds dramatic.
It does,
Yeah.
right. But the key to unlocking this massive fight came down to something, well, incredibly technical in court. Specifically, whether sworn statements made in earlier, related family cases could even be looked at in this new battle.
It's the legal system in action, sometimes at its most, intricate. And this played out before Justice McGrath in the Supreme Court of New South Wales. The case is Unicomb v. Blais.
Exactly. And this application, it wasn't even the main event, that's the big property fight itself, but this sort of procedural skirmish over 3 specific affidavits became the critical hurdle.
Yeah, how this relatively minor point was decided would fundamentally shape how the main case could even be argued.
And crucially, Justice McGrath's decision provided some much-needed clarity on a specific point of law, one that had been causing, well, the judgment itself said, considerable uncertainty for lawyers and judges right across Australia. So for this deep dive, we've really gone into the weeds with the detailed court judgment from Justice McGrath. We've got background notes on the case, looked at how this decision is being discussed in legal circles. You might see it referenced in places like the Benchmark Construction Law Review, for instance.
Right. Our mission here is basically to cut through some of that legal jargon, explore the fascinating human story behind Unicomb v. Blais, introduce you to the key players.
Who's who in this drama?
Exactly. And trace the twists and turns of the legal path they took, and explain why this specific clarification about using affidavits actually has a significant ripple effect on how legal cases are run here in Australia.
Okay, sounds good. So let's dive into the setup. Where did this all begin?
It all starts with a pretty valuable piece of real estate out in East Maitland, 2 adjoining lots, 6 Wilton Drive and 62 Mount Vincent Road.
And this property was owned by a gentleman named Dennis Thomas Wilton, who has since passed away.
That's right. Back in 2017, Dennis entered into a commercial arrangement regarding this land. On August 7th of that year, he granted what's called a call option deed to a company, HG Investcorp PD Ltd.
And that's one of Paul Unicomb's companies, right? He's a key figure later on.
He is. The initial agreement gave HG Investcorp the option to buy the property for a substantial sum, $10.4 million plus GST. There was an initial option fee paid too, of course.
Okay, but it wasn't just a one-off deal. The source material mentions a pattern of engagement.
That's right. It wasn't just one agreement left static. There were subsequent deeds of variation, one in late 2018, another in early 2019.
When did those do?
They essentially extended the period during which the option could be exercised. It shows, a sustained effort to keep the potential deal alive. The fee even saw tiny increases, like $20,001, $20,002, which kind of demonstrates continued financial commitment, however small.
Right, keeping the door open. And the stakes were pretty high because of what was planned for the land.
Very high. The plaintiffs, that's Unicomb and his companies, alleged their intention all along was to develop a retirement village on the site.
Ah, okay. That would dramatically increase its value, wouldn't it?
Absolutely. And consequently, it increases the financial upside, but also the potential for conflict for everyone involved, really raises the temperature.
Okay, so any drama needs its cast of characters.
Yeah.
This case sounds like it has a pretty complex one. Let's meet the players, the dramatis personae, as they say.
Let's do that. First, obviously, Dennis Thomas Wilton. He's the deceased property owner, the man whose passing really triggered all this. Father to Keith and Jennifer, partner of Marie. He signed that original option deed.
Okay. Then there's Paul Graham Unicomb. He's the first plaintiff.
Right. He's the principal behind the plaintiff companies, HG Investcorp and GHT Holdings. His claims are absolutely central. He alleges agreements not just with Dennis, but crucially with Gregory Blais after Dennis died.
And he claims he acted on these agreements.
Yes. He claims he and his companies invested significantly relying on these promises. For example, incurring an alleged debt of around $56,000 for rezoning costs.
Got it. And his companies.
HG Investcorp Plate Ltd. and GHT Holdings Plate Ltd., the second and third plaintiffs, they're the corporate vehicles used for the option deed and allegedly for incurring those costs like the rezoning fee.
Okay, now the other side, the defendants.
First defendant is Gregory Scott Blais. He's a really key figure. He was Dennis Wilton's son-in-law, married to Dennis's daughter Jennifer, and importantly, he was named as one of the executors of Dennis's will.
Executors being the people legally responsible for managing the estate after someone dies.
Exactly.
Yeah.
The plaintiffs allege Gregory made promises to basically carry on with the option agreement, acting as Dennis's representative and then as executor, and that this was misleading. His actions as executor are under the microscope.
Okay, who else on the defendant's side?
Keith James Wilton, the second defendant. He's Dennis Wilton's son, also a named executor like Gregory. And he's also a beneficiary under the will, meaning he stood to inherit and a trustee. So again, his actions in handling the estate and the property are central.
Right, another family member with legal duties.
Mm-hmm. And then Jennifer Amy Blais, the third defendant, Dennis's daughter, Gregory's wife, also a beneficiary and trustee, and importantly, a significant chunk of that East Maitland property eventually got transferred to her, which the plaintiffs claim was a breach of the executor's duties.
Okay, so a lot of family overlap with legal roles. Anyone else significant?
Yes, two more worth mentioning. Marie Louise Corrigan. She was Dennis Wilton's partner at the time of his death and a named beneficiary in the will.
Why is she important to this specific story about the affidavits?
Because she was a defendant in the earlier legal proceedings about the estate, and crucially, her solicitor back then, Andrew Lacey of McCabe's. Well, McCabe's is the law firm now acting for the plaintiffs, Unicomb, and its companies in the current case.
Oh, interesting.
Yes. And Mr. Lacey, acting for Marie, received those disputed affidavits back in the first round of litigation. And a key fact later on is that Marie consented to McCabe's using those affidavits when they took on the case for Unicomb.
Got it. And the last person?
Noel Ashley Brent. He was Dennis Wilton's accountant. He's important because he swore one of the three affidavits that became the focus of this legal fight. The source material notes he specifically objected to his affidavit being used in these new proceedings.
Wow. Okay, you weren't kidding about the complex web. Family, partners, beneficiaries, executors, trustees, all tangled up.
Absolutely. And those roles, executor and trustee, come with significant legal duties, fiduciary responsibilities to act in the best interest of the estate and beneficiary.
Which you can imagine creates huge potential for conflict when mixed with family dynamics and valuable property.
Precisely. Fertile ground for disagreement.
It certainly ups the personal stakes and what started as, a commercial property deal.
Yeah.
Which leads us into the first big phase of the legal battle. Let's call it Act 1, the battle for the estate.
Right. Dennis Wilton's death in late November 2020 was the direct trigger for the first round of court action concerning his estate.
So what happened immediately after his death?
Well, the executors he'd named, his son Keith and son-in-law Gregory, launched two related sets of proceedings in the Supreme Court of New South Wales.
Okay, what were they?
The first were the probate proceedings. Probate is the court process to validate a will and confirm the executor's appointment. Keith and Gregory were seeking what's called a grant of probate in solemn form, basically asking the court for a really solid, binding declaration that the main will was valid. They were also challenging a later change, a codicil, to Dennis's will.
And who was involved in that?
Marie Corrigan, Dennis's partner, was a defendant in those probate proceedings.
Okay, and the second set of proceedings?
Running alongside that were the equity proceedings. Equity law deals with fairness, trusts, that sort of thing. In this case, the executors, Keith and Gregory, sued Marie Corrigan and also the NSW Registrar General.
What were they seeking there?
They wanted the court to set aside a property transfer that Dennis had made to Marie before his death.
Ah, okay. So disputes about the will and about property transfers made before death.
Exactly. And it was within these two interconnected legal battles that those three crucial affidavits, the ones central to the later case we're focusing on, came into existence.
Right. The sworn statements from Keith Wilton, Gregory Blais, and Noel Brent, the accountant.
Correct. They were all prepared and formally sworn or affirmed in late September and early October 2021.
And they weren't just randomly created. They were part of the court process.
Yes, very much so. The source notes make it clear they were filed with the court and served on the other side specifically on Marie Corrigan's lawyers pursuant to court timetabling orders.
So standard court directions setting deadlines for evidence.
Pretty much. Orders made initially by Registrar Walton and Justice Hallen, then extended by Justice Hallen, setting deadlines for the parties to file their evidence in chief. Standard procedural stuff in litigation.
And they were received, as you mentioned, by Andrew Lacey of McCabe's, who was acting for Marie Corrigan at that time.
Correct.
Now, here's a point that becomes really important later. Were these affidavits actually read out in court?
That's the crucial thing. No, not in full. All sides agreed on this fact later. Justice Harman did appear to read some paragraphs from Mr. Brent's affidavit on one occasion in April 2022, but the documents as a whole were never formally read into the court record in open court.
Why not? What happened to those cases?
They settled. Before the cases reached a final hearing on or about March 22, 2022, Keith, Gregory, and Marie reached a settlement agreement. They signed a deed of settlement and release.
So the fight between the executors and Marie ended there.
It did. Justice Harman noted the settlement, formally dismissed both sets of proceedings on April 22, 2022, and also granted probate of the will.
And the consequence of that settlement for our story about the affidavits was?
The consequence was that those affidavits, although filed with the court, were never publicly tested, never cross-examined in open court.
And that matters because of the Harman Undertaking.
Exactly. The Harman Undertaking is that implied obligation. You get documents in one case through the court process. You can't just use them for some other purpose without the court's permission. But that obligation generally ceases to apply once a document has been read out in open court.
So because these weren't read out, the question of whether the undertaking still applied to them remained, well, alive.
Precisely. The settlement effectively froze them in that state, leaving the door open for the later argument about whether they could be used in the new case. The legal uncertainty was preserved.
Which brings us neatly to Act 2. A new front. The current contest. The fight involving Marie was over, but a new one was brewing.
That's right. With the estate disputes involving Marie settled, Paul Unicomb and his companies launched fresh proceedings on December 15, 2023.
And this time the defendants were.
This time the action was directly against Gregory Scott Blais, Keith James Wilton, and Jennifer Amy Blais, the executors, beneficiaries, and Jennifer as the recipient of part of the property. The file number is 20230045686.
Okay, and what were Unicomb and his companies claiming in this new case? Their legal team was McCabe's, with Mr. Elliott-SC and Mr. Chiam as counsel.
Yes, that's right. McCabe's, who had previously acted for Marie Corrigan, were now instructed by the plaintiffs, with Mr. Elliott-SC lead of Mr. Chiam. Their claims were significant.
Go on.
They alleged there was a binding and enforceable agreement based on the original written option deed, plus crucial oral agreements made later for that $10.4 million option to buy the property, exercisable once development approval for the retirement village was obtained.
So not just the written stuff, but verbal agreements too.
Crucially, yes. They also argued for estoppel, basically saying the defendant should be legally stopped from denying this agreement because the plaintiffs had relied on it, spent money, changed their position, etc.
And they targeted Gregory Blais specifically.
Yes. They alleged misleading or deceptive conduct by Gregory Blais, claiming he represented he would honor the deal, first as Dennis's representative and later as executor.
What else were they claiming?
They claimed they were creditors of Dennis's estate, partly because of that alleged $56,000 rezoning debt owed to GHT Holdings, and because of the alleged agreement itself. A key part of their case was alleging a breach of the executor's duties that Gregory and Keith shouldn't have transferred the property to Keith and Jennifer while the plaintiff's claims were hanging over the estate.
So what did they want the court to do? What relief were they seeking?
It was pretty substantial, reflecting the high stakes. They asked for things like revoking the grant of probate and appointing a new administrator for the estate, ordering the property to be transferred back to the executors, or alternatively, significant damages or equitable compensation from Gregory and Keith personally, plus that specific claim for the rezoning debt.
Wow. Okay, so how did the defendants respond? They were represented by an extrat, instructed by Travis Partners.
Correct. Their defense was filed around April 23, 2024. They admitted the existence of the written call option deed and the variations. That wasn't really in dispute. But crucially, they either did not admit or actively denied the alleged oral agreements and representations that were so central to the plaintiff's case.
So they drew a line between the written documents and the alleged verbal promises.
Exactly. They admitted Gregory had assisted Dennis, but denied he was ever authorized to make decisions about the property deal on Dennis's behalf. They admitted Gregory held an enduring power of attorney for Dennis, but didn't admit this made him Dennis's agent regarding the property sale from late 2019 onwards.
So they were fundamentally disputing the basis for the claim that an ongoing enforceable agreement existed, especially after Dennis's death.
Precisely. They were attacking the core of the plaintiff's case about continuing obligations.
Which brought everyone to the specific, critical, procedural point that ended up before Justice McGrath. Before the main fight over the property and promises could really get going, they had to sort this out.
Yes. The procedural skirmish. The affidavits.
Paul Unicomb and his companies, through their lawyers, McCabe's, Mr. Elliott SC, Mr. Cheam, brought a specific application. What exactly did they ask the court to declare?
They asked Justice McGrath to make a formal declaration that those three specific affidavits from the prior probate and equity proceedings, Keith's, Gregory's, and Noel Brent's, were not covered by the implied obligation, that Harman undertaking we keep mentioning.
They wanted a ruling saying they could use those affidavits freely in the current case without needing special permission.
Essentially, yes. That the rule preventing reuse of documents from one case in another simply didn't apply to these particular affidavits in these circumstances.
And this all hinged on a high court case, Hearne v. Street.
That's the one. The core legal test from Hearne v. Street is that the implied obligation, the Harman rule, applies when disclosure of a document is compelled by a court rule or order.
So the big question for Justice McGrath was, does filing an affidavit, because there's a court timetable, setting a deadline count as being compelled?
That was the million-dollar question, legally speaking. And as Justice McGrath himself acknowledged in his judgment, there was, and I quote again, considerable uncertainty in the existing law on this exact point.
Different judges had said different things.
Yes, or assumed the answer without deeply analyzing it. Even the High Court in Hearne v. Street seemed to assume affidavits filed in proceedings were generally covered, but they didn't definitively decide the compulsion point specifically in relation to affidavits filed under standard directions.
So Justice McGrath had to really dig into it.
He did. The source material aptly calls his process a comprehensive judicial odyssey, where he meticulously reviewed previous case law to get to the bottom of what compulsion truly means in this context.
Okay, let's break down the arguments. What was the plaintiff's case on this point, put forward by Mr. Elliott SC and Mr. Cheam, instructed by McCabe's?
Their main argument was that filing affidavits just to meet a standard court timetable deadline is not compelled disclosure in the sense meant by Hearne v. Street.
Why not? There was a court order setting the deadline.
True, but they argued that parties choose what evidence they want to rely on. The timetable just says when you have to file the evidence you've chosen to put forward. It doesn't force you to reveal specific private information that you wouldn't otherwise want to disclose.
So it's about choice versus being forced to reveal something against your will.
Exactly. They argued that real compulsion involves an intrusion by the court into a party's privacy or confidentiality, forcing disclosure of something they'd otherwise keep private. A standard timetable for filing your chosen evidence, they argued, doesn't meet that threshold.
What about the fact that Hearne v. Street specifically mentioned affidavits in a list of documents the rule could apply to?
The plaintiffs argued that was just the High Court listing examples of document types the rule could potentially apply to if the compulsion element was satisfied. It wasn't an automatic designation saying all affidavits filed under any circumstances are caught.
Okay. And did they bring up the fact that Marie Corrigan had consented?
Yes, they highlighted that Marie, who had received the affidavits via her then-solicitor Andrew Lacey of McCabe's, had specifically consented to McCabe's and counsel considering those affidavits for the current case against the executors.
How did they say using the affidavits would help achieve justice?
They argued it was essential, particularly for comparing what the defendants might say in their evidence in the current case with what they swore under oath in the prior cases. Checking for inconsistencies is vital, especially when the case relies heavily on alleged oral agreements and representations about who said what.
And they mentioned the position of their own lawyer, Mr. Lacey.
Yes, they noted the invidious and unusual position of Mr. Lacey, having received and read the affidavits while acting for Marie, and now needing clarity on whether he could formally use that knowledge when assessing the defendant's evidence in the new case for Unicomb.
Okay, clear plaintiff arguments. Now, what about the defendants? What was their counter-argument presented by Mr. Nackstret from Travis Partners?
They took the completely opposite view, naturally. They argued that affidavits, including these ones, are subject to the implied obligation. They relied on those earlier cases that seemed to assume this was the case.
Did they address the compulsion point differently?
They did. They argued that for defendants in a lawsuit, like the executors here, participating in litigation which includes filing evidence according to court rules isn't really voluntary in the same way it might be for a plaintiff who chooses to start the case. They rejected what they saw as a potential one-sided principle where only plaintiffs' affidavits might escape the undertaking.
What other points did they make?
They really stressed the sensitive nature of the information within the affidavit's details about Dennis Wiltie's financial affairs, his health, family conflicts, maybe even his dying wishes. They argued this sensitivity hadn't just disappeared because Dennis had died.
And the fact that opponents themselves didn't consent.
Absolutely crucial for them. They pointed out that Keith, Gregory, and Noel Brent, the people who actually swore the affidavits, did not consent to their use in this new case. They argued Marie Corrigan's consent was irrelevant because it wasn't her information primarily. It belonged to the deponents.
Did they raise any other concerns?
Yes, they worried that if the affidavits were released from the undertaking, they could potentially be misused, maybe even for defamatory purposes, perhaps leaked or put on social media. They also questioned how relevant the affidavits, which focused on the probate and earlier equity issues, really were to the current dispute about the alleged oral option extensions.
And they argued the timing was wrong.
Yes, they suggested the plaintiff's application was premature because the defendants hadn't even filed their main evidence in the current case yet. How could the court assess relevance or the need to use them now?
Okay, so really strong opposing arguments on this technical but critical point. After wading through all that, conducting his judicial odyssey, what was Justice McGrath's final verdict?
Justice McGrath's primary finding, the main decision on Issue 1, was clear and decisive. He declared that the implied obligation, the Harman undertaking, does not apply to those three relevant affidavits in the circumstances of this case.
So the plaintiffs won on that primary point.
They did.
Can you break down his core reasoning again? Why wasn't filing under those timetabling orders compelled?
His core reasoning mirrored the plaintiff's arguments quite closely. He found that filing affidavits simply to comply with ordinary timetabling orders in prior proceedings is not compelled disclosure in the specific legal sense required by the Hearne v. Street test.
Because the party chooses what evidence to put in.
Exactly. Justice McGrath determined that parties exercise a choice when deciding what evidence to file by a court deadline. The timetable itself doesn't force them to disclose specific private information they wouldn't otherwise choose to rely on. It just manages the process.
So he distinguished it from, say, being ordered to produce specific confidential documents.
Precisely. He clarified that compulsion, in the Harman context, refers to an intrusion by the court, an order forcing a party to disclose something they have a right not to disclose, usually private or confidential material needed for the case. Standard directions for filing chosen evidence don't meet that specific intrusive threshold.
And how did he handle the Hearne v. Street mention of affidavits?
He interpreted that simply as the high court listing affidavits as one type of document that can be subject to the rule if the compulsion element is met. It wasn't, in his view, an automatic rule applying to all affidavits regardless of the circumstances under which they were filed.
Okay, that's a very clear ruling on the main point. But you mentioned he also made an alternative finding, just in case he was wrong about the undertaking not applying.
Yes, he did. Lawyers and judges often do this, decide the main point, but then say, and even if I were wrong about that, here's what I would have decided on the next question.
So, assuming, for the sake of argument, that the undertaking did technically apply, what did Justice McGrath say he would have done?
He stated clearly that he would have granted leave, that is, given explicit permission to the plaintiffs to use the affidavits anyway.
Okay, so even if they needed permission, he would have given it. Why? What was his reasoning there?
When deciding whether to grant leave to use documents outside the original proceedings, courts look at various factors. The nature of the document, how it was created, the attitude of the author, the deponent. Was it created just for litigation? What kind of information is in it? How the applicant got it?
Right.
Justice McGrath considered all those factors. But he stated he gave the most significant weight to one particular factor: the likely contribution the affidavits would make to achieving justice in the current proceedings between Unicomb and the executors.
And how exactly would using these old affidavits from the estate fight help achieve justice in the new fight about the property option?
He found they were potentially highly relevant. They touched on issues live in the new case, like Gregory Blais's alleged authority or agency concerning the property deal back when Dennis was alive or just after he died.
And the inconsistency point.
Crucially, yes. He recognized that comparing the defendants' sworn statements in those prior affidavits with the evidence they would eventually file in the current case could reveal important inconsistencies. And in a case turning heavily on disputed oral representations and credibility, being able to test for such inconsistencies is absolutely vital for the court to find the truth.
So preventing that comparison would hinder justice.
That was his view. He felt it would be problematic to prevent the plaintiffs from making that comparison. He also specifically rejected the defendant's argument that the application was premature.
Why?
He found it was necessary for the plaintiffs to know now whether they could use these affidavits precisely so they could properly assess and respond to the defendant's evidence when it was eventually filed. He even acknowledged that difficult, invidious position of the plaintiff's solicitor, Mr. Lacey, who already knew the contents and needed clarity to proceed ethically and effectively.
And the outcome regarding costs.
Given the plaintiffs were entirely successful getting the declaration they sought, and the alternative finding of leave being granted if needed, Justice McGrath ordered the defendants to pay the plaintiffs' legal costs for bringing that specific application.
Okay, so a clear win for Unicomb on this procedural point. Now, let's talk about the bigger picture. What's the ripple effect of this judgment? How does it reshape legal practice in Australia?
Well, its immediate impact is providing that much-needed clarity in an area of law. The application of the Harman Undertaking to affidavits filed under standard directions that was genuinely uncertain. Justice McGrath's detailed reasoning provides strong, persuasive authority, especially within New South Wales, but likely influential elsewhere too.
So lawyers now have a clearer idea of the rule.
Yes. And this has potential consequences. One is the potentially broader use of prior affidavits. If affidavits were filed under ordinary timetables in a previous related case, lawyers might now feel more confident using them in a later case without needing to go through the process of applying for leave from the court.
So information from one case might flow more easily into another.
Potentially, yes. Think about complex litigation involving the same parties over time, or ongoing estate matters where different disputes flare up. This ruling could make it procedurally easier to bring relevant past statements into the current fight.
But there's a flip side to that, isn't there?
Absolutely. The flip side is heightened strategic awareness, or maybe a warning, for lawyers preparing affidavits. It's a bit of a cautionary tale, meaning lawyers and their clients need to be much more careful and strategic about exactly what they include in affidavits that are filed voluntarily under standard timetables. They can't necessarily rely on the implied Harman undertaking to automatically shield that information from being used by an opponent in a future related case. That information might now be considered fair game.
So it might change how lawyers draft affidavits.
It could. Litigants might be more circumspect about the breadth of information they volunteer in affidavits early on. Or if they have particularly sensitive information they need to include but want to protect, they might be more proactive in seeking specific confidentiality orders directly from the court, rather than just assuming the implied undertaking will cover them, because this case shows it might not.
It really underscores how these technical procedural rules aren't just technicalities, are they? They fundamentally shape how cases are fought and what information comes out.
Couldn't agree more. They define the battlefield.
So there you have it, our deep dive into Unicomb v. Blais. It's quite a journey, isn't it? Starts with family, valuable property, bereavement, spirals into these high-stakes legal battles over the estate, alleged broken promises, and then culminates in this focused procedural fight that actually clarifies a fundamental rule about evidence and disclosure for potentially everyone involved in litigation in Australia.
And the key takeaway from Justice McGrath's really careful judgment is that basic point. Affidavits filed just because the court set a standard deadline are generally not subject to the Harman undertaking. Why? Because their disclosure comes down to party choice, not court compulsion in the strict legal sense.
It's a powerful reminder, I think, that these intricate legal rules, these battles over evidence and procedure, that's actually where fundamental disputes over rights, over obligations, over huge financial interests are often decided. It directly impacts how lawyers have to think, what they advise clients to disclose, and how information from the past can shape future legal fights.
Well said. And perhaps it leaves us, and you listening, with a final thought to chew on. Courts are constantly trying to balance the public interest in open justice, having things aired publicly with a party's right to keep certain matters private or confidential. Especially now, in a world saturated with information. How does a ruling like this one, which potentially makes certain court documents more easily reusable, affect that delicate balance? Where does it shift the line, and what are the practical consequences for people caught up in legal disputes down the road?